We now move on to participation under Malaysian law. For participation under Malaysian law in the Penal Code, we will be looking at these few sections, right? Sections 34, 35, 37, and 149. It would be good if you can have a look at the sections first before actually watching this video. We will also be looking at sections 108, which talk about abetment, and section 128, which talks about criminal conspiracy. The joint criminal enterprises, right? This is just like in England, right? It's a serious matter. They are a menace to society because when you come together to work together, the chances of success are higher instead of working individually. Looking at section 34 first, right? Section 34, the title of it is each of several persons liable for an act done by all in like manner as if done by him alone, right? So section 34 we see here, well, let's break it up. When a criminal act is done by several persons, so it says participation by several persons, but the act was done in furtherance of the common intention of all of them. Each of such person is liable for that act in the same manner as if the act was done by him alone. Okay, so if there is a group of people participating in the criminal act in furtherance of a common intention, each and every one of them will be liable as if they did that act himself or herself. So the key thing here is common intention, right? The key thing here is that the criminal act was done in furtherance of the common intention. Now, the classic case that we will look at is the case of Mokhtar Hashim. The case of Mokhtar Hashim, I remember this case when I was still in primary school. This case caught the attention of everyone in the country because the accused was actually the Culture, Youth and Sports Minister. So it's a government minister, and he was charged together with a village headman. So two of them were charged together for murdering the victim, who was a former speaker of the State Legislative Assembly. So here, this is a case of real political intrigue. These are some of the news reports that that was in the newspapers back then. And here's the charge. So just to give you an idea of how individuals are charged, right? You are not charged just on Section 34 on its own. So you see here, this is a sample of a charge. The charge usually starts off with the date and the time and the place. So such and such a date at about this time at this place, right? And you will see here in the charge, it says, in furtherance of the common intention of you all, did commit murder by causing the death of the victim. And you have thereby committed an offense punishable under Section 302 of the Penal Code. That's what we did for murder last semester. And this is read together with Section 34. Okay, so Section 34 cannot stand on its own, right? It just talks about participating in a crime. But what crime is it? So here, for Dr. Muhtajin's case, is the crime of murder. Okay, so you see that this criminal act must be done by several persons, more than one, in furtherance of the common intention of all, right? So here you must show that there was a common intention. Now, common intention, as Molly Chang says in the book, right, it's not the same as the mens rea of intention. Here, they must have this common purpose, so to say. Like in the case of Kong Wai, right? The case of Kong Wai was a case where they were charged for possession of firearms, but during the hearing, it could not be proved that there was a common intention of the accused to be in possession of the firearms, right? So Molly Chiang says a common intention refers to an understanding or an agreement. So we're not talking about intention in mens rea, we're talking about understanding or an agreement to commit the crime. And this is a question of fact. We need to look at the facts of the case to determine whether was there a common intention. So in the case of Ho So Mui, this was a case where they found that they were charged for for smuggling drugs, right? But they found that based on the facts, the common intention was actually to smuggle this DuPont lighters, very, very expensive lighters, and not drugs. So therefore, they were found to be not guilty for the offense of smuggling or possession or trafficking drugs. Now, common intention is usually inferred from the facts, and we can see that there was common intention from the involvement of the parties or involvement in the planning of the offense. When it comes to involvement, in Dato' Mukhtar Hashim's case, it was held that the fact that the accomplice, right, or the joint perpetrator was present at that time when the offense was committed shows that he was involved. But I put that a question mark, which we will come back later. Not necessarily so, right? Being present there would be helpful to determine the person's involvement in that offense. But it doesn't mean that if the person was not present, that he wasn't involved. We'll see that later. Now in Ramli bin Awang, right? The joint perpetrator here was involved, right, in providing the rope which was used to commit the murder, as well as involved in disposing of the body. So clearly there was involvement in committing the offense, and so the court found that there was common intention. In the case of Shamsuddin bin Hassan, this was a case of husband and wife who were found in a car, and as the police were chasing after them, someone threw a packet of drugs out of the car. Now, the fact that both were present doesn't mean that just because they were present doesn't mean they were involved, and doesn't mean that there was common intention. Okay, so it couldn't be determined who actually threw it out of the car. In the case of Nanda Kumar Govindasamy, this was a case where this joint perpetrator here, he lured the victim out of the victim's house, and then there were four others who came to rob the victim and killed the victim. So the person who lured him out of the house actually wasn't present at the time when the robbery and the murder took place, but he was involved. He was involved because he was the one who actually lured the victim out. So the involvement showed that there was common intention to commit the offense. Now, when it comes to planning, we'll look at these two cases, Kiati and Vincent Bangka. And in Kiati, this was a case where they were planning to actually rob a duck feather factory. So because they were involved in the planning, so the court found that there was common intention to actually commit the robbery since they were planning for that offense. In Vincent Bangka also, they were planning to commit robbery with knives. Now, this case was something like Powers and Daniels case, right? Because when they decided to commit robbery with knives, and during the course of robbery, one of them used the knife and killed, right, and stabbed one of the victims. So the question is that were the rest also equally liable, right, for the death of that victim? Now, the court found that there was no common intention to actually commit the killing. The common intention was just to commit the robbery with knives. So unlike Power and Daniels, even though one may argue that they could have foreseen this to happen, yet you cannot say that there was a common intention, right? You cannot say that there was common intention. It was held there under our code is essential that there should be evidence of a common intention, or evidence from which a common intention can be properly inferred to commit the act actually committed. Now, not only must there be a common intention, the criminal act must have been committed in furtherance, right? It must be committed in furtherance of a common intention. So not only must there be a common intention, but the criminal act was committed as in furtherance of the common intention, right? So it must be related. The act must be related to the common intention, and we see this in the case of Kiati again, as well as the case of Lee Jun Ho. But you see that even if the court found that there was no common intention, it doesn't necessarily mean that the person, well, all of them will not be found guilty, because in Section 38 it is provided that if you were engaged in the commission of a criminal act, those people who are engaged in the commission of the same act may be guilty of different offences. Of course, if they were engaged in the commission of a criminal act and their common intention, and it was done in furtherance of that common intention, then all of them will be liable for the criminal act. But if they were not, right, it was not done in furtherance of the common intention, or they didn't have common intention, they can still be liable for different offences. So if we look at Section 38, right, particularly the illustration, it will show how those who are involved can be guilty of different offences. So A attacks Z under such circumstances of grave provocation. Thus, killing of Z will only be culpable homicide, not amounting to murder. B, having ill will towards Z and intending to kill him and not having been subject to provocation, assists A in killing him. So here, A and B both engaged in the commission of the criminal act, which was to kill Z. However, right, since there was no common you can see here, even though both of them were engaged in causing Z's death, B will be liable for murder, but A will only be liable for culpable homicide, not amounting to murder, right? Culpable homicide not amounting to murder, because he was acting under grave provocation. So it can be that people were involved in committing the same offense but end up being found guilty for different offenses. In the case of Baba Nanda Sharma, this was a case where the three of them chased the victim, and Baba B held on to the victim's hands while the other two beat the victim until the victim died. Now, in this case, it was found that Baba didn't have the intention to kill, didn't know that they were going to kill him, right? So while the other two who beat up the victim until the victim died were found guilty of murder, Baba Nanda was only found guilty for culpable homicide, not amounting to murder. Okay, so that's Section 34, right? A criminal act which was done in furtherance of a common intention. Now, Section 35 is quite similar, except that instead of the act being done in furtherance of common intention, it was done with criminal knowledge or criminal intention. So Section 35 here, you can see, let's break it up, right? You can see that here, the main thing here, the key difference here is that the act was done with a criminal knowledge or intention, with that knowledge or intention. So this one seems to be referring to the mens rea. There must be the criminal knowledge or intention, unlike the common intention earlier that we saw was not so much about the mens rea. So breaking it up, right, when an act which was criminal, because it was done with a criminal knowledge or intention, and this was done by several persons, so each who joins that act with that knowledge or that intention will be liable, as if it was done by him alone with that knowledge or intention. Okay, so that's Section 35. Now moving on to Section 37. This is cooperation by more than one person of doing one of several acts. Section 37 provides that if the offense is committed by several acts, so whoever intentionally cooperates in the commission of that offense by doing one of these acts, so if the act is committed by perhaps 5 acts, so if a person intentionally cooperate in doing one of the 5 acts, either alone on his own or jointly with another person, is said to have committed that offense, even though he didn't commit the other 4 acts. Okay? Right. Now, to understand this, we need to look at the illustrations. So have a look at this. Have a look at illustrations. It really helps in understanding how this provision works. So A and B agree to murder Z. by severally and at different times giving him small doses of poison. So A is going to give Z some poison, then later B is going to give Z some poison, then A is going to give Z some poison, right? So A and B administer the poison according to the agreement with the intention to murder Z. Z dies from the effects of the several doses of poison so administered to him. So here A and B intentionally cooperate in the commission of the murder. Since each of them did an act by which the death is caused, they are both guilty. Even though the acts are separate, they didn't do the acts together, they did separate acts. But this was basically all the acts are committed with the intention to murder Z. So they cooperate by doing one of several acts. Another illustration B, A and B are joint jailers and they are in charge of Z, who's a prisoner. So A is watching over Z for 6 hours, B for another 6 hours. So A and B, they actually want to cause Z's death. So they cooperate in causing that effect. They work together, they cooperate by illegally omitting to furnish Z with food supplied for that purpose. So Z dies of hunger. So A omitted to give Z food for 6 hours, then the next 6 hours also omitted to give food to Z. Now both of them will be guilty of the murder of Z. And illustration C. Now A is a jailer again now, but it's just A in charge of Z. So A wants to cause Z's death. So A omits to give Z food. But Z didn't die, right? The starvation is not sufficient to cause the death. And A is dismissed from his office, B succeeds him, and B does the same thing, but this was without any collusion or without any cooperation with A. Okay? So illegally omits to supply Z with food, knowing it's likely to cause Z's death, so Z dies of hunger. B is guilty of murder. But A didn't cooperate. See, there's no cooperation with B. So A is only guilty for attempting to commit murder. Right? And finally, offense committed by a member of an unlawful assembly. This is found under section 149. And yeah, let's break it up. So if the offense is committed by any member of an unlawful assembly in prosecution of the common object of the assembly, or such as the members of the assembly knew to be likely to be committed in prosecution of that object, then every person who at the time of committing an offense is a member of the unlawful assembly will be guilty of that offense. So basically, if there's an unlawful assembly, someone in the unlawful assembly commits an offense, and this was in prosecution, right? Basically, it's almost like in furtherance, but it says it in prosecution of the common object of the assembly, or that members knew that it was likely to be committed in prosecution of that object of that assembly, that everyone in the unlawful assembly will be guilty. But the first things first, we need to determine what is an unlawful assembly. And for this, we need to look at section 141. So you see here, unlawful assembly is a gathering of 5 or more persons. 5 or more persons with the common object under A, B, C, D, or E. Okay? So that's an unlawful assembly. 5 or more people come together, they assemble together with the common object to do A, B, C, D, or E. So here, if something was done in prosecution of the common object, so what is the common object? Again, we need to go back. The common object could be A, B, C, D, or E. So examples, in Ong Chin Sing, the common object was to cause hurt, right, by dangerous weapons. Right, cause hurt by dangerous weapons. So they 5 or more of them came together, and their common object was to cause hurt using dangerous weapons. And this was held to fall under section 141C, right? Commit any mischief or criminal trespass or other offense, right? See, So you see for 141C is very wide because it covers other offense. So if the common object was to commit any offense, then it will fall under 141 if there is 5 or more persons involved. Another example is this case of Fong Yin Ching. This is a Singaporean case where a group of people plan to go for a march, something like what the lawyers did some years ago. They did a march, they did a walk for peace and freedom. This was way back in 2014. But this group actually consists of opposition members, and those who support opposition. The plan was to march all the way down to this is City Hall in Singapore, which is the headquarters of the government. Now, it was considered to be an unlawful assembly because they did not obtain a police permit, right? They did not obtain, they didn't manage to get a police permit. And so they were found to be an unlawful assembly under 141B as well as 141C. C catches everything. But 141B is to resist the execution of any law or any legal process. So if any member does an act in prosecution of the common object, so basically, right, if they done it as a result of the common object, because of the common object, right, putting it very simply, then everyone else in the unlawful assembly will be guilty of that offense, right? Everyone else will be guilty of that offense. So here the example, the case of Jahiruddin, which is basically a story about two rival gangs. So one of the gangs came together, and they consisted of more than 5 people, or rather more than 4 people. Okay, and they wanted to take the place of the head of the rival gang. So that was the objective. That was the common object, and as a result of the common object, one of the gang members killed, or rather shot, another gang member. And everyone in that gang, which is considered to be an unlawful assembly, is liable because the reason why he was shot was in prosecution of the common object. Right, it was because of the common purpose to take over the leader's position. And even if it was not in prosecution of the common object, as long as the members, right, if the members know that it was likely to be committed in prosecution of the object, then everybody will be guilty of that offense. Now, another case, a case of Tan Keng An. This was way back in 1965. And this took place at Pulau Senang. You can see the little red island there below Singapore. Now, Pulau Senang was quite interesting, right? Because it was meant to be how should I say, an island prison. So there was no walls, no fences or electric fences and things like that, no barbed wires. Right? Prisoners were kept there and they were allowed to move around in the island quite freely. And this was one of the wardens. Apparently, he was his brainchild, and fortunately, I think he died because of that. You see, there was a riot which took place. Where there was a riot which took place in 1963. So prisoners, they burned down buildings, they caused hurt, and they also killed 3 of the wardens. Now, all of those who were involved in the riot were found guilty of murder, the murder of the wardens. Okay, it was considered to be an unlawful assembly, and the common object was basically to take over the island, right? And the killing of the wardens was done in prosecution of that common object. So all of them were liable for the murder. Now, the difference between Section 34 and 149, right? Section 34 talks about where the act was committed by more than one person, but 149, there must be at least 5 who committed the offense. Section 34 deals with any offense any offense can be in the penal code or outside of the penal code, whereas 149 is very specific. We got to look at the situations under 141 to see whether is it an unlawful assembly or not. And finally, there's common intent, right, under Section 34, Whereas 149 talks about what was done in persecution of the common object, or whether you knew that it was going to be done in persecution of the common object. Okay, right. So that's it for section 149, right? And that's it for basically joint perpetration of offenses under the Penal Code, sections 34, 35, 37, and 149. Subsequently, we're going to look at the abetment as well as criminal conspiracy.